Okay, ready? This meeting of the Greenwich Township Land Use Board, October 10th, is called to order.
This is a regular meeting of the Land Use Board of the Township of Greenwich. Adequate notice of this meeting has been given in accordance with the Open Public Meetings Act, and that a notice was published in the Star Ledger and Express Times newspaper. Notice was posted on the Municipal Bulletin Board in the Township Administration Building in Greenwich Township, New Jersey, and notice was filed in the Township Clerk.
Roll call.
Paul Bean, Class 1.
Here.
Joseph Chitello, Class 2. Frank Marchetta, Class 3.
Here.
Ray Buckwalter, Class 4.
Excuse.
Bruce Williams, Class 4.
Here.
Kathy Colin, Class 4.
Here.
Don Marie Condas, Class 4.
Here.
Mark Scuderi, Class 4.
Absent.
Gary Hill, Class 4.
Excuse. Excuse.
Joseph Fiamma, Alternate 1.
Here.
Jeremy Blunt, Alternate 2.
Here.
Bill Cognac, Alternate 3.
Here.
Pam Peslis, Alternate 4.
Okay, please rise to the flag salute. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, first order of business is the September 12th minutes. John, you had a number of revisions which, rather than, we'll let you go through.
So before the meeting, I polled the members. There's some typographical corrections, which I don't think we have to read in the record. I got them all. I photocopied it and gave it to Susanna. So the only additions that I want to read into the record, and Susanna's going to put page numbers on it. So if you go to page 6, which will be the second to last page, and you start. Now, let me start with that. Mr. Taban commented on how dividing the affordable units between the Dumont roadside and the Dowell site would be a good option. Mr. Creighton said that he thought option C was agreed on prior to the hearing. The board made a motion to let anyone that had already made comment come back to make additional comments. The motion was made by Bill Cognac, seconded by Mark Scuderi. Mr. Perone made a comment clarifying where option C came from. So, now, Vice Chairman asked if there were any further comments from the audience. Seeing that there were none, a motion was made by Gary Hill and seconded by Kathy Collins to close the public hearing. I want to add the following. Before the next sentence, it says, a motion was made by Gary Hill and seconded by Bill Cognac to adopt the following resolution. I want to add the following. The board conducted a straw poll to determine whether the board preferred option A over option C and to determine whether the board preferred option C with a 61-60 unit split between Dumont and Dowell, or a 71-50 split between Dumont and Dowell, period. The straw polls were as follows, : preference for option A over option C, 4 yes, 5 no. Preference for option C with a 61-60 split, 0 yes, 9 no. Then we go back. A motion was then made by Gary Hill and seconded by Bill Cognac to adopt the following resolution. And then the minutes, again, other than typos, accurately reflect what took place during the meeting. Does anyone want to discuss anything else about the minutes?
Any other changes? Yeah, I know. Okay. Well, let's approve them as amended, and then we'll have them made. So if there's no other changes or suggestions, then can I have a motion to approve the minutes as amended? Don Marie, second?
I just want to find out if I'm able to vote on it, because I recuse myself after the meeting.
No, you're right, okay.
Yeah, I figured.
Right. Only people who were here for the entire meeting can vote on the minutes. If you weren't, this is one of the few times you abstained. And if you weren't here, you obviously abstained. You had to be here for the whole meeting to be able to vote on the
I
minutes.
didn't watch it on video. That's fine.
Okay. Right. So, Don Marie, we still need a second. Oh, Kathy? Okay.
I had to do a roll call just in case.
Okay, roll call then.
So, Joseph Chitello. Frank Marchetta.
Abstain?
Bruce Williams.
Yes.
Kathy Cullen.
Yes.
Don Marie Condas.
Yes.
Joseph Fiamma.
Yes.
Jeremy Blunt.
Abstain.
Bill Cognac.
Yes.
Pam Peslis.
Okay. Now, these were rather lengthy minutes because of the public meeting and everything, so, there was a lot written up. Ray had, the chairman had sent out an email basically asking, is it really necessary?
And by the way, this is not an email that he sent to everybody. This is an
Yeah.
email that he sent to Wilson Vice Chair and me for a legal opinion.
Right, so he just sent us basically saying, is it necessary to have all of that information? To which, and Frank, kind of echoed on that too. So John gave us a legal opinion.
Right, so, my legal opinion was, the combined requirements of the Open Public Meetings Act and the Municipal Land Use Law mandate that reasonably comprehensive minutes of all meetings must include the following 8 items of information. Number 1, time and place of the meeting. Number 2, board members present. Number 3, subjects considered at the meeting. Number 4, names of persons appearing and addressing the board during the meeting. Number 5, names of persons represented at the hearing by an attorney. Number 6, actions taken by the board. Number 7, board findings and reasons for actions taken. And number 8, vote of each member. And I conclude by saying significantly, while the law prohibits anything less than listed above, the law does not require anything more than listed above. The board can do what it wants with the detail of the minutes, but not to make light of the situation, but the minutes should be able to be read in minutes. It shouldn't take hours. But the minutes must include the 8 items of information set forth above. So again, if you want them real detailed, God bless you.
So
You don't have to.
So basically, I want to get your, from my perspective, especially with what's going on, I actually thought, I like the detailed minutes. These end up getting published or presumably on the township website at some point in time. But we don't have to do it, so...
To put it this way, in a case like this, I agree with Bruce. If you have a hearing on an application, okay, especially, some of those long hearings you have that go on for a couple of months, then I have the opposite opinion, because if there's a question, there's a transcript. For example, let's use John Ray as...
But we're videotaping now.
I understand. So I'm saying that if you have a long application, in my opinion, the minutes should be just the 8 items. Right, the minute shouldn't be a transcript. The transcript's a transcript, and especially since you're videotaping, like Frank says, you can either watch the video or you order a transcript and read the transcript, but there's no reason for the minutes to be that detailed, because the municipal land use law says that you can take the official minutes and they're admissible in court. Now, if the minutes say one thing and the transcript says something else, ultimately the transcript's going to prevail, but you don't even want to have that situation. So I think in this case, Susanna did the right thing by having the detailed minutes. And if we have a hearing on an application, you go to the 8 items. What subjects were considered? Which people appeared and addressed the board? Which of those people were represented by an attorney? What action did the board take? And why? And the vote of each member. And that's why the vote of each member, when you technically, you have the roll call, you see who's there. If you had a unanimous voice vote, no problem. If you had a non-unanimous voice vote,
Okay, so
technically you wouldn't see the vote of each member. That's why I suggested...
how's Susanna going to know which way to do it?
Because normally she asks, voice vote or roll call. But she's on top of it.
No, I mean in terms
Yeah.
of whether to go big on the minutes or not big on the minutes.
I would say the rule, again, this is not a legal opinion. The legal opinion is whatever you want, but I would say go, less is more. Do what's legally required and no more than what's legally required. That would be my advice.
My suggestion is the minutes outside of what we have should be a summary. Because then once you get into it, cherry picking, and it doesn't give you the whole flavor of it. If you want the flavor, like Frank says, there's the videos now, and if you gotta go to court, you gotta transcript.
Well, and I guess you can always have a member or the chairman or whatever say, I think this should be in there, and then add that in. So I would say that for the future, we'll go with the less is more. And unless somebody feels something has to be in there, then we'll add that in.
And that's what the discussion's about.
Yeah.
Okay?
All right? So, I think that wraps up that. So, new business is the master plan consistency review of the MF1 ordinance introduced at the first reading by the Township Committee on September 20th, 2018, and rezoning Dumont Road site for a 71-unit municipally sponsored, 100% affordable housing development.
Okay, so, Susanna handed out the MF1 district zoning ordinance in the form introduced by the Township Committee on September 20th, and this is dated September 19th. And I guess the question to Dan, the question for the board is, when you do a master plan consistency review, the question is the ordinance consistent with the master plan, or if it's inconsistent in any way, where are the inconsistencies? And again, legally, you could say it's not inconsistent, but in the case where it's entirely consistent, you might want to say that, but we should probably get the planner's opinion on that.
And by the way, I'll say that Dan Halvin is standing in for Beth McManus, despite what the placard says.
So do you have an opinion? We don't have to get you sworn in, this is not a hearing on an
Sure.
application.
My opinion is that the ordinance is consistent with the master plan, and that it's consistent with the third-round amended housing element and fair share plan that was adopted on September 12th, 2018, and endorsed by the Township Council on September 20th, 2018.
Okay, so his opinion is consistent with the master plan, so if anyone has any questions for him, ask. Otherwise, if someone wants to make a motion, it's very simple. Just to, you would say that the board finds that the MF1 ordinance as introduced on September 20th is consistent with the master plan, and then Susanna, if that was the motion made and seconded and voted on, Susanna would send out a memo or a letter to the township clerk telling her that the planning, that the land use board did a master plan consistency review, and that was the finding.
Any questions for Dan, or? If not, then we'll entertain a motion to deem the MF1 as consistent with the master plan.
If you making that motion?
Well, I was going to give somebody else an opportunity, but
Eleanor's making the motion.
I'll second it. Now, roll call, please.
Paul Bean?
Yes.
Joseph Chicello?
Yes.
Frank Marchetta?
Yes.
Bruce Williams?
Yes.
Kathy Cullen?
Yes.
Don Marie Condis? Joseph Fiamma?
Yes.
Jeremy Blunt?
Yes.
And Bill Kenyon.
Yes.
Okay.
Okay. Now, that does our business. We do want to go into
I'm
Closed
suggesting, a motion to go into a closed session so I can give you an update on what's happening with the declaratory judgment action. So specifically, I'm going to ask someone to make the following, and after I'm done, say, yeah, I make that motion. The motion would read, whereas NJSA 10:4-12, the Open Public Meetings Act, authorizes the board to exclude the public from that portion of a meeting at which the board discusses certain matters. Whereas the board is about to discuss such a matter where confidentiality is required for the attorney to exercise his ethical duties as a lawyer, specifically attorney-client privilege legal advice regarding various issues arising from the remaining options being considered for the township to meet its third round affordable housing obligation under the pending declaratory judgment action titled In Re Greenwich Township Compliance with Third Round Mount Laurel Affordable Housing Obligations, docket number WRN-L-228-15. Whereas the board believes the public should be excluded from those discussions, now therefore be it resolved by the Greenwich Township Land Use Board on October 10, 2018, that the board now go into closed session and the public be excluded, and that the board believes that the discussions conducted in the closed session may not be disclosed to the public because they will involve attorney-client privilege advice and information. Anyone want to make that motion?
second. Is, Judge Jones second. And are we anticipating any action after we come out?
Zero.
Zero action after we come out, so there's...
And I can tell you this, I don't want to jinx myself, but this closed session, we should be out of this closed session by 8 o'clock. This is a really short one. And in case people don't want to hang out till the end, even though no action's going to take place, I can say on the record that I sent a letter in today to the Land Use Board and to the Mayor and Township Committee formally advising that option B was withdrawn by Florio Carucci, and that there's no pending application or request by them or the so-called warehouse developers for anything. So you guys want to call for
Okay.
a vote on this motion to go into closed session?
All right, we need a roll call for that?
We didn't.
Yeah.
No, we didn't do it yet. This is for the closed session. So let's do a roll call for the closed session.
Paul Beam?
Yes.
Joseph Ticello? Frank Marchetta? Bruce Williams?
Yes.
Kathy Cullen?
Yes.
Don Marie Condos? Joseph Yama? Jeremy Blunt? And Bill Conley.
Okay. So for members of the public, we will be coming out. You can come back in to hear them adjourn.
Fine.
Or-
That's all we're gonna
Yeah.
do. Nothing. So if you have a second it?
Anyone out there?
Okay. All in favor of coming out of executive session?
Bill, you can open up, please, somebody's here.
Opposed? Abstained? None? Unanimous.
Okay.
Okay. That completes our business. Is there a motion to adjourn?
Motion.
Second, and Bill Kenyon seconded. All in favor of adjourning? Against? Okay. We are adjourned. Told you so.